Hello and welcome to Vestralex free online community classes on law. This is a free legal literacy initiative by you, for you, and possible only through the generous contribution of our seniors, mentors, and guides. Today, we have the good fortune of having with us Mr. Chander M. Lall, sir. He's a senior advocate from Delhi High Court, and I request Mr. Dhananjay Gupta to kindly introduce sir.
Yes, sir. So, Senior Advocate Chandramohan Lal is a prominent legal professional practicing in the Delhi High Court and Supreme Court. With a vast and distinguished career, he is recognized for his expertise in a wide range of legal disciplines, including civil, criminal, and constitutional law. Over the years, he has handled numerous high-profile cases, demonstrating exceptional advocacy skills and a deep understanding of law. As a senior advocate, he enjoys the trust and respect of both the legal community and his client. His contribution to the field has established him as a high regarding figure at the Delhi High Court. Sir has also authored comparative advertisement, law and practice in intellectual property law. I hand over back to Mr. Kishore.
Uh,
Thank you. Thank you for
Thank
the
you so much,
introduction.
Dhananjay ji. Chander sir. I'm sure that there are introductions which are very elaborate, eloquent, and fancy, which would still not match the stature of who you are and what you've done. So it's
Thank you. That's very
with
kind of you.
folded arms, sir. Very warmly welcome you, and I'm grateful to you, sir, first of all, for accepting my delay. And at the same time, sir, I most humbly request you to kindly guide us with respect to this very interesting topic of intellectual property rights practice for young lawyers. So we welcome you, sir.
Okay. Thank you very much. Thank you very much for having me on the program. So always a pleasure to talk to young people. So IP law is a highly specialized field. And when I started intellectual property law, it wasn't, there were very few people practicing it. And I still remember everybody saying that you only have four acts that people need to know, and it's reasonably simple, law. But I think over time, people have understood the nuances of it. A lot of youngsters I find are interested in intellectual property law today, but not too many know what it really entails. So I've had the privilege of handling intellectual property law right from scratch, so let me just explain. I think intellectual property law can be put in probably three compartments. The first compartment is what we call IP prosecution work, which is filing trademark, patent, design applications, copyright applications at the trademark or at the intellectual property office, and pursuing and prosecuting those applications. Then with that, there are other nuances of opposition, rectifications, cancellation actions at the trademark registry level. This is mostly office work. It entails a lot of handling of bulk files. Each application is not a thick litigation kind of an experience. Most of the applications are between the applicant and the registrar. So there is no third party involved. It is to prosecute that file and take it through to registration and the grant of registration, and then maintaining that registration. This form of practice requires a lot of good record keeping. So while it's easy, it's not difficult to file a IP application. It's putting a form together, putting 5 pieces of information and filing it at the trademark office. But you file eventually, as you grow in practice, you file hundreds and thousands and tens of thousands of applications, which you have to pursue. There are timelines to be met. So record keeping has to be very, very good. So it's a huge administrative task to run an intellectual property law office for prosecution work, because the administration, most of the work is administrative. So when I started my own firm, I used to file the applications myself, prepare them, file them, maintain records, diaries, deadlines. There are strict deadlines. I mean, had large clients, multinational clients, and my classic example was that you could lose many cases in court because, litigation involves a lot of nuances on how the judge reacts. But if you lose a trademark renewal once in 10 years, an important mark like Coca-Cola or Amazon or something, the client will never excuse you, and they will leave you and go. So it may sound easy that once in 10 years you have to file for Amazon to be renewed or for Coca-Cola to be renewed. But when you have tens of thousands of such renewals coming up, you may miss one. Clients, of course, also maintain records, but you as a law firm are expected to. So it's a lot of record keeping. The second avenue of intellectual property is litigation. That has its own skill set. That's like any other litigation. Of course, it is specialized. Patents require an understanding of technology, or at least not having an aversion to technology. Trademarks have their own nuances. It may sound very simple whether A is similar to B or not, but it has a lot of nuances in pharmaceutical. What is the elements of confusion? It's a lot to do with the human mind, how we behave. Then we go into areas of copyright. Why is intellectual property so important today? Everything that is happening around us is intellectual property. Nations are built today not on actual property, but on intellectual property. Everything requires technology. You can imagine, you'll never put a black colored liquid in your mouth, but if you put Coca-Cola on it, you'll drink it happily. So you can imagine it's what we see every day in our everyday lives, and therefore there is a lot of intellectual property happening. You write a book, there's copyright in it. You make a film, there's copyright in it. You play music, there's copyright in it. Then that is nuanced to say you play music at a wedding, you have to pay royalties. You play music at a hotel, in a restaurant, you have to pay royalties. A book, you make a film out of it, you have to take permissions. Film, you have to take permissions from the underlying script. So there are lots of, and copyright has its own, it's one of the most fascinating subjects that I've ever experienced, and all of us, and because copyrights don't require too much of, legalese in the sense of registration, etc. The moment you create a copyright work, it's protected not only in India, but globally, because as members of the Berne and Universal Copyright Convention, so all that is said, for example, if this is being recorded, that is subject matter of copyright, which is now going to be protected all over the world. Similarly, you write something down, even the little notes that you may be making right now are all subject matter of copyright. So copyright is being created, and protectable copyright is being created by millions and trillions of people every day, every second, every minute. And when that will require to be protected, nobody knows. Because suddenly you may create something which is of value, and then you get out to protect it. And unfortunately, most of the creators don't know how to protect it because they are, simple people doing it in their little offices or homes, etc. So it needs assistance of lawyers, and then people are worried. I've met a lot of people who say, enforcement of copyright, or how do I enforce? I don't even know about it. So that has its own nuances. And then patents, again, you'll be surprised, I do a lot of patent work. I do chemical patents, I do telecom patents. I have no science knowledge. I'm not a science student. And I find that to be an asset. Rather than being a liability, I find that to be an asset. Because it takes hours of conferences for me to understand those technologies. And I understand them from scratch. I don't know the terminologies, I don't know the expressions. So I have to spend time with my briefing counsels to explain to me, break it down in a simplified manner. As a result of which, I know the pain area and I can explain it better to the judge. So I find that to be because the judge is not going to be trained in that technology either. So I find that, and I've told many judges that please give me dates of hearing. So because I will have to spend maybe 20 hours over that technology so that I take only 1 hour of yours. I'm able to explain it to you in 1 hour. So that's a challenge. So I encourage people to enter patent law, even though you're not science students. That's a takeaway. Don't think that because I don't know, I'm not a science student, I can't practice patent law. So and then the third form of intellectual property is transactional. Most of your contracts today will have intellectual property contracts, whether it is I hire you, you will maintain confidentiality of the data that you find in my office. I hire you to work in my factory. There may be methods of working which are confidential to the firm. I hire you in a research laboratory where I'm making patents and you'll be bound by confidentiality. I may license to you, certain technologies which will have intellectual. So there's a lot of transactional intellectual property happening where almost all contracts today, commercial contracts, will have an intellectual property clause, requiring a deep understanding of how those should be drafted. So a lot of the large corporate law firms do and practice what is transactional intellectual property. But I find that most of the commercial law firms who are not specialists in intellectual property are not able to make a mark in core intellectual property because of, I think, what I assess as poor record keeping measures. And in my firm, we actually, when I was part of my firm and as a founder of that firm, I actually developed our own software for these deadlines and automated deadlines, etc. So it was a huge administrative task. I think that's why I got designated finally as a senior advocate and left the firm and came to court, because you have to do many things. You have to go solicit work. Most of my work was foreign clients, so we had to travel a lot abroad. You come back with work, then you have to make sure the work is delivered. Intellectual property requires a lot of manpower, not very skilled manpower, but a lot of manpower, because you need to feed in a lot of data. There are hundreds and thousands of files. So you need to manage an office, and then you've got to, again, revert to your clients, and then you've got to prepare cases and go to court. So it's a wide gamut of things. I used to love my travel, and then I came back. I loved going to court. I loved being in my office, but it was a large administrative. I was more a manager than a lawyer. I'm happy to say now that I'm in court, I'm more a lawyer and a zero manager. So yeah, so that's broadly, I could rant about IP forever, but specific questions would help me focus it more. Sorry, I think you're muted.
So thank you so much, sir. It's
Yeah.
so you called it a rant, but I think very categorically you spoke about all of it actually, and you inspired also, you motivated also. That
Okay.
you don't know about like if you're not, because actually I have also had this apprehension. I've done copyright matters. I think that's how I got to know more about you. And yet I was apprehensive of taking a patent matters always, because I thought that since I don't have a science background, but I'm grateful to you for setting aside that.
Right.
So, sir, how you when a person comes across anything that they are writing or that they are creating, uh, where does that person or at what stage does that person should consider that it's time to consult a lawyer and get it protected?
Well, ideally, I think intellectual property, especially for a country like India, should be made mandatory at school level. I think today creativity starts at school level. And lack of knowledge is what is costing us a lot of loss of property. Intellectual property is so valuable and it's created with difficulty but lost very easily. That's a problem. So I would think that now, for example, when the internet came in, the World Wide Web and the internet came in, everybody thought that whatever the most asked question that time was, is everything on the internet free? And the answer of mine was, no, it's not. Nothing has changed. Merely because you can access that information, it's like a whole world's library open to you on the net, doesn't mean that that whole library becomes free. It is still protected by the same rights as it was earlier. Today, creativity is going to happen through use of AI, for example. And who owns that? So, I represented the film industry a lot. And I mostly did work for the Hollywood studios. And I saw the difference between how Hollywood understood intellectual property and how we Indians and the Bollywood and the other vernacular industries understood Our industry did not know anything about copyright, though they were creators. A very famous film actress, I'm happy to name her at all, Mrs. Shabana Azmi at the time was a member of parliament in the Rajya Sabha. And I had the opportunity of meeting her. And I was just, she would say that we watch each other's films on a video cassette. And I said, where do you get the video cassettes from? And they get it from a local rental library at that time. And I said, do you know that all rental libraries in this country are illegal? Because rental is a right of films which you can take licenses for. And there were no blockbuster stores like they were in America, which were doing formal renting. And therefore, the film producer was not even making money out of the rental because there were no rental facilities available for him. And he didn't even know that rental he could have, made money out of it. So imagine the loss of revenue of somebody like Mrs. Shabana Azmi, who's highly educated, who was a member of parliament, whose livelihood depended on the industry, didn't have enough knowledge about the subject that she herself was so actively involved in creating. And that is the unfortunate position of most of our creatives, that they don't know what they are holding. Most of our fashion designers today, they don't know how to protect. They say we get copied all the time. So what do you do about it? We do nothing because it's probably going to be too expensive. When I reached out to the Bollywood industry and said, why are you not protecting your films? They said, we don't have the money. I said, hello, a film costs, at that time, maybe 70, 80, 90 crores, which was a lot of money. So you're willing to spend that kind of money in producing a film, but you can't spend another crore for protecting it. I said, Hollywood is coming to India where their revenues are 1% of the world revenues, and they have me hired here. And don't tell me you who make 800 films compared to 200 films of Hollywood can't find enough money to protect it, because by the time the film is produced and brought out and released, they spent all their money. And it's not a priority to protect it because they don't know how. So I really think there is a need for understanding intellectual property at a very base level in our population. It's almost like water and food that we eat, that it must become a part of education because we have so many creative people. In the telecom field, 30% of patents, the inventor is Indian, but not in India. He's sitting somewhere else and creating. In the pharmaceutical field, I would estimate that 40% of the patent applications have inventors as Indians, but not Indian patents. So there's a huge brain drain where foreign countries get our educated people who go through our education system for which this country contributes. And then when it is a time to return that favor, they are taken away by another country because they understand and respect intellectual property. We neither understand it nor respect it. And whenever we talk about the government level at intellectual property, we talk about foreigners coming and trying to impose their IP on us and wanting us to pay for that intellectual property, whereas we are a third world country and why should we have to pay? Which is very unfortunate because we are the only country which perhaps as a population are the largest creators of intellectual property in the world. And yet we don't understand it. So people are educated here, taken away abroad, educated on intellectual property, and then they become creators and contributors to those economies. So I think it's almost a necessity that at every year of school, some form of intellectual property in a very easy fashion is taught to children. Because by the time a child is 12 today, he's a creator of intellectual property. He may be an entrepreneur today because of the online, there's so many opportunities. And he will be creating technology, he may be creating a brand, he may be creating a new type of business methodology, he may be creating an online, portal of some sort. And all of it is intellectual property, which is very quickly disseminated to thousands and millions of people because of the access to the internet and online facilities. But how do you protect that? Can you protect it? Do you recognize it? Do you understand that it is intellectual property and property which can earn you a lot of money? Unfortunately, I think it's lacking at that base level. And if I were the government of India, I would definitely make this my policy goal to say, IP everybody, right down to the last villager who ever lived in this country, must be educated with, at least understand what it is. And because he will, during the course of his life, even at farmer level, you see people having invented so many interesting farming technologies, all of which get lost. Each of our villages, little towns have GIs, whether it's Kolhapuri chappals or Mathura's peda. These are all GIs. Do we recognize it? Basmati rice. So at every level, even as an agrarian society, we are creators of intellectual property. We have so much heritage, traditional knowledge. Have we protected any of that? That traditional knowledge has been taken away by the West and utilized in their pharmaceuticals. We have not protected it. We don't even have a full understanding of the traditional knowledge which is out there. So nobody's collected any of it because I think there's a lack of education on this front.
So if I would have any power in my command, I would make a new ministry in the government. I would call it Intellectual Property Rights Ministry, and I would make you the minister for that. So it is such a beautiful vision that you shared, that every single person, the farmers, the ev- all content that has been created. And so this is something. So so if you'll permit me to share, I'll just share this very small anecdote. Two, sir, actually very important things which shaped my mind with respect to what is the future of any kind of legal service that may be provided to people. And I do not see anything growing more exceptionally than intellectual property. So I met this one person once who introduced me actually to the concept of intellectual property. I was on a flight from Delhi to Bombay for some matter. I was dressed in my black and whites. So he recognized that I'm a lawyer. He asked me, "Who are you? Where are you going from?" So I told him Delhi to here. He told me that I'm going from Delhi Supreme Court to US Supreme Court. And then he told me that he has a firm, and his firm has how do I say, his firm has teams as per continents. The Asia team, this team, that team, everything. So then I asked him, obviously, curiosity, that so how did you start? So he said that I studied at Harvard. He had this whatever education, LLM maybe. So he studied at Harvard, and after that he got an internship at one of these movie companies. Some, I don't know, Disney, Marvel, etc. I don't know, something of that sort. One movie came out around that time. That movie, it had some intellectual property matter. He said that the work was for 1 week, and he got paid $1 million for that. So that was at the start of his career. And
That's right.
so he suggested that you should think about it. And so how I see what you've shared, it is something which can bring a lot of prosperity to all lawyers. And this class cannot in any manner suffice ever. So we'll require a lot more sessions with you. So every single thing that you've mentioned, sir, copyright, with respect to trademarks, with respect to patents, and etc., etc. So this is the premise for how I greatly appreciate your vision and your mission and what you just shared. So there are questions also.
Before you go on, let me share another classic example because you mentioned you heard me the other day arguing about
uh,
music.
So I heard this very interesting line also that you said, and which just blew my mind. So it was, I'll tell you later.
So I'm arguing for music just for the understanding of the audience. If you play music, you may purchase that. You may be on Spotify. That's meant for your personal use. If you play it commercially in a restaurant, adding to the ambience of your restaurant, or in a bar, adding to the ambience of your bar, or in a discotheque, where the core of your business is music, or at a party in a hotel where you play music through a DJ, you have to pay a royalty for the owners of the sound recordings and the underlying works. Now, when you're arguing before a court, today they are standing up and saying, how are you charging, for example, at a party of 500 people where per plate cost is 6,000 rupees, and a DJ you're paying maybe lakh or 2 lakhs? Why are you charging 70,000 or 1 lakh for music rights for that event? And they come and question it as if, look how they're charging. I'm like, can I question you that when I come to your bar, a 10 rupee beer is costing 50 rupees? How come that is not questioned? So you want to buy a Mercedes Benz for the price of a Maruti? Why should I not question that? So it's just shocking that we don't treat IP as IP at all. And even businessmen who run businesses dependent on music get up and challenge the right of the music companies to collect for what is their property. And that very same restaurant, bar, five-star hotel is able to charge 20,000 rupees for a room to spend a night, 500 rupees for a beer, which costs 20 rupees, 6,000 rupees for a plate of food. Questions why music should be charged. I mean, isn't that because we can't touch it? We only perceive it through our ear. We don't consider it as property. We feel somebody is creating music for us for free. And he must give it to us for free or at a price that we must decide. Who are you to decide what I want to sell my property at? It is my property. It is not an essential commodity. Ask the creator how much. I've written 2 books of late. Ask me how much time it took. 20 years to write a book. It's the most painful experience of writing a book because you keep changing your mind as a professional. You have to take out time. You enter into what is called writer's blocks. I now understand it better. Don't tell me you can take that book away from me and publish it as you like. Do you know how much time it's taken me? It's taken definitely more time than preparing a bottle of beer. Likewise, a music composer, have you ever seen a music recording? How much time it takes? Have you ever seen a film production? I have so much respect for those actors. If you ask me to repeat what I'm saying right now and say, Mr. Lalo, I just missed that portion. Can you repeat the same words and the same dialogue? I'm going to say, oh, no. Now don't make me do this. I'm speaking ex-tempo. But if I have to remember this as a dialogue and repeat it 50 times before I get the perfect shot,
Certainly.
you know how much time it takes? There's no respect. That is meant to be free. So when we were enforcing films and we went to the magistrate and said, I've caught 5,000 CDs and the man should be put to jail because there's a criminal penalty, the magistrate would turn around and say, kya movies to dikha rahe hain? What is wrong? Jaan thodi le lenge uski. So it's very unfortunate that as Indians, we don't respect it, we don't understand it, we don't respect it because we don't treat it as property. Whereas in the West, they treat it as property, they respect it as property and make money out of it and become rich. US is not rich, China is not rich, Japan is not rich because of real estate or resources that they have. Yes, they have a lot of natural resources, but they create and protect that creation. And they make lots of money. So today, who are the best brands in the world are the people who have created, like Amazon, Google. They rule the world because they live off intellectual property. What do they live off? And they protect that intellectual property with their lives through, and they force other nations to follow because it's their way of selling and it's their way of making money. And there's nothing wrong with making money through property that I create and build. We will recognize somebody walks into my house, I should be able to stop him. But if somebody walks into my property, which is intellectual property, that I should not be able to stop him. Why should I? That's supposed to be free. He can walk all over that intellectual property.
So one question before I take questions which have been raised by the people, and I request everyone, please, आपके जो भी सवाल है ना, आप उनको डालो question में chat box में डालो, and this is the most important session I would say you would have, which can actually change your life and your legal practice and everything actually, if you really get the essence of what is being spoken about, what sir is saying right now. So, sir, what would be your advice to any young legal professional, maybe practicing IP or maybe wanting to practice IP, uh, with respect to startups? Like how you mentioned that if Indian startups or if any startup for that matter of fact, any organization or person, individual entity, they respect their intellectual rights, then automatically they will prosper. So it becomes also it's a tangible asset, as you very rightfully said, that it just cannot be seen, so we don't perceive it. But the fact is that it exists, so it has some value to it. So, sir, in that manner, what would be the advice that you would want to give to all the people who are here and people who would be watching this, referring to this later on YouTube? That where can lawyers possibly bridge the gap with startups and help the startup also grow and his practice also grow and the entire country and everything also?
Well, see, we are living in a world where it's today not difficult to get information, provided you're looking. You Google, intellectual property, and you'll get all kinds of material available to you. Easily understood, understandable. People write about it. So get on to Google and spend 2-3 hours, and you'll be much the wiser 3 years down, 3 hours down the line. You've got to understand the subject. Then only will you head in that direction. You're creating a new product, for example. I want to create something new. Today, let's say there's lots of happening in nutraceuticals or, it's lifestyle related products. And lots of people are interested. I want to create a lifestyle product, vitamins and what you're going to make new formulations. You're going to do a lot of effort in developing a new product, you're a startup, so you're obviously doing something new and different. Understand what you want to create. Not only understand what you're going to create as that product or as that business, but understand what is the possibility of that creation. So I am trying to launch a new soft drink, for example. What all can I protect and which direction should I head? So I must have a brand. It can't be that my daughter's name is Nirma, so I call my drink Nirma. A certain amount of research will be required to find that brand. Then should your bottle have a particular shape and design, that will be covered by a design. The formulation that you'll put into the bottle could be subject matter of a patent today. So I can't for the life of me in 1 hour of seminar or even explain all of the intricacies of intellectual property. But somebody's got to make that effort, which will tell you what you're going to create and what direction you should take and what safeguards you should put in place as you walk into it. Now, patents is very important that you file a patent application before you make it public. So you can't start creating this new pen, which is going to have a new technology, launch it in the market, and then think, oh, do I have a patent because now the product is successful? It's too late. We were talking at a seminar with judges also there, talking about, do we do excessive patenting? And how bad is excessive patenting? That people file for patents which are useless patents. And only 10% of the patents or 5% of the patents are useful patents. So we are overburdening the system with patents. And I'm asked the question, is there over patenting? And I'm just looking at them. I said, you know what? I have visited pharmaceutical companies in the US. And you know what the strategy is? Patent has to be not disclosed. So when I'm running a laboratory and I'm trying to find a new drug, every week, whoever is trying to invent that new drug, working in, say, anti-cancer or something, they file a patent application for what? What transpired in the last week. So that if there is a leakage, I protected it by a patent application. So this one cancer drug, which I may not even at the end invent, and I may spend billions of dollars towards it, I may have 1,000 patent applications. I am paying for it. It's not overburdening the system. And when I eventually get my wonder drug, if I am not able to protect it, because one patent application I didn't make and some inventor who was working on it went out and disclosed it to the world, I've lost everything. So one patent, useful patent, which may not even be useful in the end, may require 1,000 applications. So it's an expensive exercise, but yes, he undertakes it because the day he gets that cancer drug, he makes billions out of it. Then when he comes to a country like India, we say, now we are poor people. So we should not protect that patent because we must get that same treatment. As a short term, it sounds very attractive. Yes, why should our people not have access to the same drug and it's so expensive. But now It's a balance between the two. If you don't pay that drug company its worth due, for the largest time, we didn't protect pharmaceuticals in India. So what did the drug companies do? They never filed in India. You were never able to get. My brother had kidney problems. We couldn't get a drug in India. We had to import it. So our own population was deprived of it. Now, to say that now that drug, yes, you can have compulsory licensing provisions for prices where there is a life-saving drug and you need it. There are those exceptions. But respect that cause. And if they are filing 1,000 applications, there's nothing wrong with it. Now, we look at it as a burden on the system. I ask myself, why can we not? It's making money. Nobody's filing a patent application for free. Why can we not have a patent office which can deal with that kind of load and burden? Are we short of staff? Are we short of skilled staff who can handle this? Or are we just short of sight? So we look at everything as a problem. We don't look at development of an asset. It's one of the most amazing examples. YKK zippers. If you see a zip fastener, it has a handle. And that handle sometimes comes off. And it has a hook. Now that hook used to break off. I don't know if you remember that hook sometimes broke off and the whole zipper became...
I got YKK right here.
Yes. Now
So
they did a hole on that hook. They made a hole. Just so that now that became a little more pliable so you could put that handle in. That hook was subject matter of a patent. It sounds so insignificant, but for 20 years they had the exclusive monopoly to make that hole. And they made billions on that one technology, which was going into public domain because every zip fastener needed it because now that hook was not breaking. If the hook was not breaking, that means the zip was intact. If the zip was intact, that means your whole trouser was saved. So they look at every small incremental increase in technology as a patentable technology. And that is why a brand like YKK becomes a market leader because it innovates, because it is encouraged to innovate. Unless you innovate, you're one of many. So every product today to find its niche in the market innovates. Now, unless you recognize where you need to innovate and how you will protect that innovation, you will not innovate. And you must be assured that if I put in so much money on that innovation, I will get my returns. Otherwise, you will not have the incentive to innovate. And unless you have the incentive to innovate, if trademarks didn't exist, all I'll try and do is develop sell water under Bisleri or find similar sounding names to deceive people, but not develop my own reputation and goodwill to develop that Bisleri brand or a Coca-Cola brand. But to develop that brand, I have to start from scratch. But I can copy. So right now, we are only trying to copy. How long will you survive? China did that very sensibly. We must follow the China example. China allowed all their population to infringe intellectual property for over a decade. Because they said, we don't have the capability of creation. We will not protect your intellectual property. You can go to hell. We have the population. We are a big market for you. You want to come into China or not, we will go out. They sent out people. They went and stole intellectual property, came back and developed. And China became known for theft of intellectual property. They used that knowledge. They didn't sit on that theft. They used each of those technologies to develop their own. They copied first and then became the innovators. In 3G, 4G of your technology, they copied. In 5G and 6G, 7G onwards, it's going to be all China. So they stole 3G, 4G maybe, but built on it. They didn't sit on that stolen goods. We neither allow us to steal openly, and if we steal, we sit and make money out of the theft, but don't innovate over that. So I don't know, there is something seriously wrong with our thinking because I don't think our leadership understands how important innovation is for a country like ours, which is the population is our biggest asset and we call that a liability. We have the youngest population and we aren't able to exploit them. We have the most fertile and brilliant minds in the world because when you get out on the streets, the desi jugaad has to work and that jugaad creates so much of creativity, it's not even funny. But nothing is protected and nothing becomes monetized. as a result of which we remain poor because we don't recognize the property that we have sitting with us. We don't harness it. We don't cultivate it. We just chop it down, kill it, and wherever we see innovation, we discourage it. We say it's not good for our country, and our whole thinking is narrowed to just being pure intellectual property thieves rather than creators, whereas we have the largest creators who don't understand that they can create and make money.
So, just beautiful thoughts. So I'm stuck back to that one particular point where you said that even if you're stealing, then at least use it, right? Use it at least for now. This generation will use it. Next generation will get something better out of it. So,
Yeah.
it's the truth, sir. Actually, like, and so I just want everyone who's watching this on a Windows XP, which is not original or licensed, to kindly just like the video of this particular class simply because of this particular thing. Otherwise, I don't. Obviously, sir, we've never asked anyone for any likes, but so it's just fantastic. I just let the questions from people come in. Miss Samita Dikshit, advocate, she had the question. Samita ma'am, please, you may ask your question. Samita ma'am, are you there? Okay, Janvi, तब तक एक बार आप पूछिए. Samita ma'am, if you're there, you just let me know that you're still here.
Hello, sir. My name is Janvi, and I'm handling the patent prosecution at Chandigarh University. So,
Okay.
I completely relate with your first point that you raised, that to maintain the IP office, a huge amount of administration work is required. So, large amount of deadlines are to be tracked. So my question is, what is the difference between prosecution and litigation as a career for a budding lawyer? Like, if someone is practicing prosecution over a year and then they want to pursue litigation, what will be the difference for them with regard to career aspects? Sorry.
Yeah, it's a very good question, Janvi. It's entirely different skill set altogether. Litigation is you being a lawyer.
Yes, sir.
Litigation is no different from being any lawyer. It's just a specialization in a particular field. Prosecuting IP, you need to be a manager. You need to be an administrator. You need to understand technology. You need to be a stickler for timelines. You need to have systems which are unbeatable. So it is not a one-man job. Simple litigation is a one-man job. You appear in court, it's only your performance in court that matters. If you perform well, you'll get more work. In an IP practice of prosecution, you are a very small player. You have to make sure that the people who are feeding in the data and your database system is so foolproof that you never miss a deadline.
Correct, sir.
And that's the only way you can grow in IP. Now, a single company today may have 200, 300 trademarks. A single multinational will have maybe 600 trademarks in India itself. Then you could file in Nepal, Sri Lanka, Bangladesh, in the subcontinent. Then if you have a good system, you could file online, everything online. You could file in other countries as well. Now you can imagine if you have a portfolio of one client of 3,000-4,000 files.
Yes, sir.
With deadlines, different deadlines, what kind of administration you need. So anybody wanting to do, and the moment you have that kind of administration requirements, you will have people. The moment you have people, you're running now a whole organization. And I think one of the weaknesses that I felt in my practice was I didn't have the knowledge of management. And I would advise people to do law and an MBA to understand how management, how to manage your accounts have to be good, your finances you have to understand, how much do you need to spend, how much do you need to charge, because it's not one big charge, it's smaller charges for many things, little things that you do, how to beat the market. So it's a whole different, it's a marketing game, it's an administration game in prosecution. It's not a legal game at all. The legal part is very small and very little. So you need legal input at a very minimal level, but an administrative input at a very high level. So don't be a good lawyer, be a good administrator, you'll succeed in prosecution. You don't need to be an administrator, but be a good lawyer to be a litigator.
Sir, if you want to succeed in litigation,
Then you just develop. Then one thing about litigation, it's not so much about knowledge of the law. Of course it is. You need to read a lot.
yes, sir.
Because the more you read, the more you sharpen your skills of how to answer questions. But the other thing is you're managing people, you're managing another judge this time. So you need to be a very good reader of, the other person's mind. You may not know your law backwards. It's what the judge wants to hear. So you need to have people skill. You need to read the judge's mind. So sitting in court helps you a lot. So whenever I have a difficult case, I sit in court. What is the judge's mood today? And I think as a senior advocate, because we are in court all day, we understand what will happen. I can almost 50% predict what's going to happen in that case today.
Yes, sir.
And when I sit in court and I see the judge's mood, that prediction becomes 70%. Because when you're sitting there and seeing the to and fro with other cases, you understand the mood, you know the judge, and you're able to then mold your arguments of what the judge wants to hear. It's not how much. And so a lawyer will fail. I have a lot of knowledge and I want to give that knowledge to the judge. And if you give the judge, give an impression to the judge that I know it all, but you know nothing, you will get no order, even if that is true.
Yes, sir.
So you've got to go along, see what is the mood of the court, and mold yourself according to that, which perhaps on a day-to-day basis you should do in conversations, that listen to people, imbibe what they are wanting to listen. Then can you engage people in a conversation? Hence, can you engage a judge? So I try and make my appearances in court as interesting. And whenever sometimes you get stuck, maybe crack a joke to ease out the atmosphere.
Yes, sir.
So sometimes little tricks work.
Sir, one more thing I would like to share. For 1 year, I have assisted Justice Sanjay Kumar in the Supreme Court. I was a law clerk. So for one whole year, we used to sit in the court, and I used to wonder why the advocates are sitting for so long just to argue for 2 minutes. They are sitting for the whole day in the court, and now I get the answer why they used to sit in the court just to understand the mood of the judge so that they can argue.
So I carry my laptop. I don't sit outside. If I have to wait for a case, I will sit inside.
Yes, sir.
Because a lot of, subconsciously you're gaining a lot of information of what's going on, the mood of the court,
Yes, sir.
the whole environment of the court. So then you're much better prepared. It's like when you get onto a sporting field, you want to get in there early so that you get the feel of the stadium, you get the feel of the grass.
Yes.
Same thing here. A lot more here because you just get that environment, you get the feel, you get comfortable, you understand what is the mood of the court today, what is the mood of your opponent. You just look around and you can do your own work, but you learn a lot in that process.
Yes.
So if you have to sit around, you might as well sit in court and hear cases. That learning is invaluable.
It's irreplaceable, sir.
Absolutely.
Thank you.
Thank you so much, sir.
I hope you got your answers, and through your
Yeah.
interaction, you
Thank
also
you,
got a lot to learn. Thank you so much. Smita ma'am, are you back? You want to see if your mic unmutes now? Okay. So, all right. So I will ask on your behalf what you've written. So you say thank you. Okay. My question pertains to how far does IPR operate when any creative work is used with the help of AI? I frequently see people using ChatGPT, etc., for elaborating on ideas. The ideation per se is original, but obviously AI borrows heavily from other resources. So how far would IP protection go?
So AI is right now, AI is not at that level where it's, there is deep learning, there is computer learning, but AI is relying on a lot of data, pre-existing data. The computer intelligence is coming from the power of AI is the memory that the computer possesses. And that's the scary part about AI, because the human memory can't match the computer memory under any circumstance already. The only edge that the human brain has over the computer brain is the analytical skill and the creative element of it, which deep learning and computer learning is also quickly catching up with, because it is able to collate and understand a lot of data far better than a human brain. So as a result, when you use AI as a tool, AI has many elements to it and lots of IP attached to it. Somebody who has developed that AI tool is one contributor to it. Somebody has trained that AI tool in a particular way is also a contributor to that whole exercise. And then currently the most important part is what are the questions you put to the AI. So if you go on Chat GPT, the answer will depend on how you frame your question also. But be rest assured, just like the internet, the AI doesn't come free. What comes out of Chat GPT is copyright protected. It is not free for all to use. So you be rest assured that Chat GPT has picked up a lot of information from the net of other people's copyright and purge that out to you. So be very mindful of that. The US Supreme Court was asked, there was a patent application in the name of a AI system because it developed two technologies. I think it was for a tiffin box and for a beam, that the light beam, like a police, the beacon light, created wholly by the AI. The US Supreme Court said that no, we cannot accept AI as the inventor. Inventor still has to be a human being. So a human can be the inventor so long as he has used AI as a tool. And it's no different, for example, if I'm making a statue, whether I make it a hammer or chisel, or then I use a electric tool to make it. The end statue is my creativity, though the hammer and chisel and the electric tool were tools that I used to create it. Both will have copyright, even though the electric tool made me make that statue faster than with a hammer and chisel. So the AI will give us those answers faster. But it is creating a lot of nuances, because a lot of the research which would take me months happens now through AI and use of AI very quickly without application of mind by us. For example, in the medical field, X-rays which go into X-rays and X-ray reports, if they go on, they go onto a computer, AI is able to pick up results of how fractures are identified. The AI tool is able to then quickly look at the next X-ray and say, this looks like a fracture, without even a human intervention, because it's got so much information from all doctors around the globe who have assessed X-rays and have found a particular nuance in the X-ray to mean it's a fracture. So the AI tool will pick that up. So I think a lot of AI is nothing different from how we perceived the internet to be at one time. It was a path-breaking technology. Internet was a rage. Now I think the next rage is AI. But AI has its own, as it develops further, I think machine learning will outrun human minds and make its decisions based on criteria that are set in, and then those criteria need not be human set up criteria. But I think we're a little bit away from that, though we are getting there.
That's fantastic, sir. It's actually what I understand, sir, right now is that there is a entire new jurisprudence, I think, probably which will come up with more developments in the artificial intelligence domain. How you mentioned that who's the creator? Actually, that person created the application, or the application created something else. So it's like whether God created in human being, then human being created child. Now, who's the father?
True. Yeah, it's a good example.
It will be very interesting to see. But so hopefully we'll get more insights. I'll request one session with you specifically with respect to technology and IPR, just technology and copyrights primarily. So I am actually stuck with respect to understanding that the relevance of intellectual property, but obviously that just my thought. So I'll just hold back. So there is one question from Mr. Harinesh Pandya. Harinesh ji, sir, I request you to kindly ask your question.
You think all these people are on YouTube, so they're not being able to They're probably not dialed in. I don't see any Harinesh here.
So it's there in the chat. Oh, so he may have left. So I'll just read his question. It's a very interesting question, actually. So he says, when it comes to human rights violations, the RTI Act includes an important provision for ensuring that the information is disclosed when there is compelling public interest, even if it involves information typically protected under IPR or other exemptions. Section 8.2 empowers authorities to disclose information if the public interest outweighs the potential harm to IPR or other protected areas. I think so. So please, your views, sir.
No, I mean, a lot of the disclosure that is made, RTI is only for public documents. So you can't, for example, if I have a patent application, even if there is public interest, you can't ask for that patent application till it's formally published for it to be disclosed through an RTI process. So RTI is strictly, and most of your RTI responses in many cases will be that this is confidential information. So for example, when you apply for drug licenses and you have to disclose certain confidential information to obtain drug licenses, the drug controller will not hand over under the RTI your intellectual property. But if there is public interest, and RTIs, of course, there are processes of challenge. So if there is a threat of disclosure and you go to court, then there will have to be an adjudicatory process of when that disclosure is to be made. Because if RTI became that widespread that every document given to a public office will be available to third parties, nobody would file for intellectual property rights, which are protected rights, or where I register a confidential contract or a confidential data. It's not given out that easily. And that public interest aspect in intellectual property does get overridden. In particular, in patents, there are provisions for compulsory licensing where your pricing is not correct, where there is a emergency situation in public interest that will override intellectual property rights. But I think these are exceptions, and the law is mindful that these exceptions are necessary, because if we make too many exceptions, then nobody will disclose. What is a patent? It's a technology which I'm encouraged to disclose to the patent office and make a public disclosure in return for a 20-year monopoly. If you are not going to give me that 20-year monopoly, then I will maintain that secret and I will not give it to anybody. And if I don't give it to anybody, there's no question of having a disclosure through the RTI. So there has to be a balance of that. Public interest can't be invoked at the shortest notice and say this is public interest to disclose it. So there is a judicial process by which you will have to make good your public interest argument. And yes, there may be cases where public interest will override intellectual property and that disclosures will be made, but those are very few and far between.
So I think it sufficiently answers Harinesh's question. So we've also taken up your time, but it just went very fast. So deeply grateful to you, sir,
Thank you
for
very much.
giving us this opportunity to learn from you, and at the same time for helping us explore this very unique and versatile dimension of law. I thank everyone who's participated, and sir, I thank you on behalf of all of them who's had this occasion of joining and listening into you today, and everyone who will be referring to it in the future.
Thank you.
So, sir, but I also, with that, sir, I'm just grateful to you for sharing that view that every single person, including the farmer and the person of every single startup who's creating anything, we have 1.5 billion people who are creating things consistently, yet people have no idea whatsoever about intellectual property. So whatever we can do ever in support of this thought of yours, that we may help disseminate more information which may constructively help people, everyone in general, not just lawyers, but everyone in general. But we'll pray for your guidance for that.
Thank you. Thank you.
Then you want to say something?
Yes, one thing I would say, sir said that I have written two books. The one is the one book is I can see in the sirs that my majesty at the pleasure of His Majesty, that can be that is seen from the camera, that from behind, sir, at your back.
Can't see you.
No,
There.
sir.
This is
It is, I can see.
Oh, it's at.
Yes. Yes. So I mentioned about one book,
Yeah,
and
both my books are there. There's the other one.
okay. So I got to see that the another one. So I apologize that I mentioned only one book, but yes, you have written two books. So the second book is at the pleasure of His Majesty, sir.
That's right. That's right. Thank
So,
you.
so we hope actually, sir, sir, how does it sound if we may have some sort of an occasion where we discuss these books individually, probably? Maybe I'll ask you at some other
Sure.
point.
Sure, I'm happy to. Anytime.
Thank you, sir. Thank you so much,
Yeah.
sir. So, thank you so much, sir. Deeply grateful to you for your time and uh, just that, sir. So kind of.
Thank
So
you very much. Thanks a lot.
Thank
shall I
you, sir.
seek,
Thank you.
shall I
Thank you.
seek your permission to end the class?
Yes, please. Thank you.